Summary video 11. We had to read chapter 20. Chapter 20 is on the laws governing labor management relations. It starts off by saying the legislations that govern labor management relations, which are the Wagner Act of 1935, the Taft-Hartley Act of 1947, and the Landrum-Griffin Act of 1959. The Wagner Act, or the National Labor Relations Act, guarantees the rights of workers to organize and bargain collectively. It forbids employers from engaging in specified unfair labor practices, and it aims to facilitate the formation of labor unions, and it settles labor disputes by collective bargaining. The Taft-Hartley Act bars unions from engaging in specified unfair labor practices. It makes collective bargaining agreements enforceable in U.S. district courts and provides a civil damage remedy for parties injured by certain prohibited union activities. The Landrum-Griffin Act governs the internal operation of labor unions. It requires financial disclosures by unions, and it establishes civil and criminal penalties for financial abuses by union officials. And then the Labor's Bill of Rights provides protection for employees against their own unions. The National Labor Relations Board is an administrative agency set up to interpret and enforce the Wagner Act. The functions are monitoring the conduct of the employer and the union during an election, and preventing and remedying unfair labor practices, and establishing rules and regulations interpreting the acts. So the jurisdiction of the NLRB is granted by Congress over any business affecting commerce. Employees omitted from NLRA coverage are federal, state, and local government employees, employees in the transportation industry, and those covered by the Railway Labor Act, independent contractors, agricultural workers, and household domestics, persons employed by a spouse or parent, and supervisors, managerial, or confidential employees. Procedures in unfair labor practice cases. They're initiated by an employee union or employer filing an unfair labor practice charge with the appropriate regional office. The charge is examined by field examiners. The regional director determines if a complaint should be issued, and an attorney informally tries to resolve issued complaints. And then regional office attorney prosecutes the case before an ALJ if the informal negotiations are unsuccessful. Labor organizing. Dissatisfied employees can contact a national union that represents employees engaged in similar type of work. The union sends a representative to explain what unionization can do, and if the employees want to pursue unionization, the organizer helps them run a campaign to convince the workers to accept the union as their exclusive representative. The NLRB Rules of Conduct prohibits interference with employees exercising their Section 7 rights, and unfair labor practices differ from violations of board rules. Board rule violation may result in NLRB declaring the results of an election invalid and ordering a new one, and the commission of unfair labor practice. The board may ignore the election results and order the employer to bargain with the union without a new election. The 24-hour rule prohibits union representatives and employers from making speeches to captive audiences of employees within 24 hours of a representative election. Employers are required to file an Excelsior list with the regional director, which an Excelsior list contains the list of names and addresses of all employees eligible to vote. All unfair labor practices are considered violations of the board's election rules. unfair labor practices by employers, interference with organizing. The NLRA prohibits employer interference with restraint of or coercion of employees in the exercise of Section 7 rights. Expression of a view, an argument, or an opinion is not evidence of an unfair labor practice and must contain threats of reprisals or promises of benefits. Domination or support of labor organizing. If the employer recognizes a union that does not represent the majority of employees, that is a violation of Section 8A2. The union dominated by an employer will be disestablished. Union unlawfully supported by an employer will be decertified. The Labor Management Committee is a forum in which workers communicate directly with upper management, and it's illegal under the NLRA if it has an impact on working conditions unless the employees are carrying out a traditional management function. Discrimination based on union activity. Discharge of an employee must be based on poor performance rather than union activity. Appropriate bargaining unit may be an entire plant, a single department, or all employees of a single employer. A mutuality of interest should exist among the proposed members of the unit, and regional office first determines the appropriateness of the proposed bargaining unit when it receives a petition for a representation election. Good faith bargaining. Following procedural standards laid out in Section 8 of the NLRA. Unfair labor practices under Section 8A5. Failure of the employer to bargain in good faith. Taking unilateral action on a matter subject to bargaining. Failure of a union to bargain in good faith is a violation of Section 8B3. Subjects of collective bargaining. Mandatory subjects are subjects over which the parties must bargain, like rates of pay and wages, hours of employment, and other terms and conditions of employment. Permissive subjects are subjects that need not be bargained over, like management decisions concerning the commitment of capital and basic scope of the enterprise. Strikes are temporary, concerted withdrawal of labor. Lawful strikes, like an economic strike, are nonviolent work stoppage for the purpose of obtaining better terms and conditions of employment under a collective bargaining agreement. An unfair labor practice strike is nonviolent work stoppage for the purpose of protesting an employer's commission of an unfair labor practice. Unlawful strikes. Employees are not legally protected and may be discharged by their employer. Sit-down strikes are employees remain on the job but cease working. Partial strikes, only some of the workers leave the job, and wildcat strikes, not authorized by the parent union and are in violation of the collective bargaining agreement. There's also jurisdictional strikes, or work stoppages for the purpose of forcing an employer to resolve a dispute between two unions. And secondary strikes, unionized workers of one employer go on strike to force their employer to exert pressure on another employer with which the union has a dispute. Boycotts are a refusal to deal with, purchase goods from, or work for a business. Secondary boycott is illegal, which is a boycott against one employer to force it to cease doing business with another employer with which the union has a dispute. A hot cargo agreement is an agreement between the union and the employer that union members need not handle non-union goods and the employer will not deal with non-union employees. It's considered an unfair labor practice under Section 8B in all industries other than construction and garment industries. Picketing is stationing of individuals outside of an employer's place of business to inform passerbys of the fact of a labor dispute. There's informal picketing, which is designed to truthfully inform the public of a labor dispute, and jurisdictional picketing, done by one union to protest an assignment of jobs to another union's members. Organizational or recognitional picketing is picketing designed to force the employer to recognize and bargain with an uncertified union. And violent picketing and massed picketing are unlawful. The global dimensions of labor management relations are many U.S. and multinational corporations seek cheaper labor overseas. Labor laws of other countries may be different from those in the United States. Some scholars believe that uniform laws across the globe are necessary. Like workers' rights should be protected regardless of where they work, and uniformity may benefit multinational firms. Um, in some countries, labor organizing is still banned. The International Labor Organization attempts to harmonize labor laws around the world, set minimum standards, and leave enforcement to local law agencies.